Good day, ladies and gentlemen, and welcome to the Access to Capital Web Conference Series. At this time, all participants are in a listen-only mode. Later, we will conduct a question-and-answer session, and instructions will follow at that time. If anyone should require assistance during the conference, please press star, then 0 on your touch-tone telephone. As a reminder, today's conference call is being recorded. I would now like to introduce your host, Ms. Heidi Jeffries. Please begin. Thank you.
Welcome. I'm Heidi Jeffrey with Foley and Lardner, and I'm pleased to welcome you to the Access to Capital Web Conference Series. Joining me today are three outstanding speakers. Dave Atchison is the President and CEO of Ponder & Company. Dave Anderson is the owner of Healthcare Futures. And Rick Seiden is my partner, resident in our Los Angeles office. Before I turn the presentation over to Dave Atchison, I'd like to go over a few housekeeping items. Today's program will last approximately 90 minutes. The PowerPoint presentation will be available on our website at foley.com. You may also click the print icon on the bottom right-hand side of your screen to print to a PDF. If you are experiencing problems with live meeting, please call 866-493-2858 for technology assistance. Today's program has been set up in both a discussion and an interactive question and answer format. We encourage you to submit written questions during the program. Simply click Q&A on the menu bar of your screen and type your question. We will respond to written questions and also take live questions at the end of the program. To ensure you get the most out of today's presentation, we encourage all participants to maximize the PowerPoint to full screen usage. You can do so by hitting the F5 button on your keyboard. As a reminder, today's program will be available on Foley's website early next week. Our agenda today will focus on affiliations between nonprofit healthcare providers. Dave Atchison will discuss the current M&A environment. Dave Anderson will discuss transaction structuring options. I plan to cover debt management and finance considerations. And Rick will end today's presentation with a discussion on Catholic and non-Catholic hospital affiliations and state attorney general and antitrust issues. Now, I am very pleased to turn today's presentation over to Dave Atchison.
Thank you very much, Heidi, and thank you for all the participants, for dialing in today. My role in the presentation is to focus on what I would consider non-traditional forms of accessing capital for nonprofit hospitals and health systems. We commonly see this with the standalone community hospitals as well as with the multi-regional health systems. And we'll provide some case studies at the end of my presentation to explain how we have encountered that. The first slide is really to bring your attention to the number of announced hospital transactions. This goes back to 2007, and as you'll note in a quarter-by-quarter analysis, there's been substantial increase in terms of announced hospital transactions over the last 2 years. In 07, 08, 09, around 60 transactions a year, popping up to 88 in 2010, 113 in 11, and we're on track right now for 2012 to probably end up around 120 to 130 announced transactions. It's interesting on the next slide, you'll see that the number of transactions where there's a not-for-profit successor has been relatively unchanged during this 3-year period that we've analyzed. Around 2/3 of those transactions have resulted in a nonprofit successor. And by that, the explanation would be a situation in which typically a nonprofit standalone community hospital would merge into a nonprofit regional health system. So what are the drivers of consolidation? What is really moving this? And you'll see on this wheel chart on the next slide a number of different things that we've identified over the years that lead to consolidation. I guess I would point out in the lower left 3 that seem to be most significant. Historically, it has been the very topic that we're talking about today, and that is accessing capital. Many hospitals find themselves in a situation in which they cannot individually access capital to the extent they need to do that and to be successful. Increasingly, we're seeing motivations relating to physician alignment. Some hospitals have determined that physician alignment strategies will be important going forward, and they don't have the resources to devote to that. They don't have a plan, and they look to large health systems to assist them and kind of bootstrap their position into a more aggressive role in terms of physician alignment. And clearly all of this is being driven by some uncertainty with regard to new healthcare delivery models and what form that will take. Other trends in mergers and acquisitions, we're seeing a lot of joint ventures. They have picked up momentum in the last couple of years. Some of you may have heard about DLP Ventures. That's Duke and LifePoint, Duke Health System, a prominent academic medical center in North Carolina, aligning with a for-profit provider, LifePoint. They've announced about 4 or 5 transactions together. This enables Duke to expand its network without the same level of investment, which would be required if they acquired all of these assets. This also enables Duke to counter the expansion in their market, their natural market, which is North Carolina area, from Novant and Carolinas. LifePoint gets a good entree to acquisition opportunities, and they leverage the Duke name. And these are hospitals that generally fit LifePoint's operating model, and really are smaller hospitals typically that Duke does not have particular experience in managing. However, in the most recent transactions that they've announced, Duke LifePoint announced an acquisition of a very large hospital in Marquette, Michigan, which is well outside of their footprint, and we know that they're involved in a transaction down in Florida. So 2 markets outside of their natural geography, and also going into larger hospitals and health systems rather than the smaller rural community hospitals where they started this project out. LHP has also been fairly active. Those are it's a for-profit entity that historically had built their business around a joint venture model. They have announced 2 3-way transactions. Unfortunately, the first one cited there has been disbanded for reasons that we're not quite certain of. But they did close the transaction, the Bay Medical Center and transaction in Panama City, which included Sacred Heart Health Systems in Pensacola, as well as LHP. Continuing with other trends, we see an unsolicited offers more frequent, really unheard of in the nonprofit healthcare space up until a couple of years ago. Steward Healthcare announced an interest in acquiring Jackson Health in Miami. Regional Care Hospital Partners made an unsolicited proposal to Cheyenne Regional Medical Center, and Wake Med targeted Rex Hospital. We've also seen an increasing number of failed transactions in Salinas, California, in Ohio, and in Westlaco, Texas. Our predictions for 2012, as I've already referenced, we'll see about an 8 to 10% increase in terms of activity, probably ending up somewhere around 120 to 130 announced transactions. We believe that for-profit activity will continue to be at its highest levels in 15 years. There are 12 or more for-profits or private equity-backed groups who have announced acquisitions in 2010 and 2011, and all of these entities have pressures from their investors to grow their businesses. We believe that nonprofits will continue to be very selective and consider disposition of underperforming assets. Not-for-profits certainly want to guard their current credit rating. They're not staffed to handle a large number of additions at any particular point in time, nor are they motivated to do so other than for strategic benefits and opportunities. We do see not-for-profits exiting certain markets in order to concentrate their resources in more strategic markets. Joint venture structure, again, will continue to proliferate. As I mentioned, Duke LifePoint, HMA, LHP, and others all offer a joint venture model in addition to an outright asset acquisition. State-level legislation will trigger additional activity. In Florida, there is a House Bill 711, which has required all public governmental hospitals to be valued and to analyze their quality and performance levels relative to for-profit peers in that marketplace. That's been fairly active. We'll also see government scrutiny continue. FTC and state attorneys general remain very interested in the transfer of nonprofit assets to for-profit hospitals in particular. The timing of a bigger wave remains somewhat unclear. We'll think it's likely to start in 2013 as cuts are anticipated to begin in 2014. So we're in a bit of a suspended animation phase here until there's more clarity on reform and reimbursement. We're also unsure when we'll see a rise in bankruptcies and problem assets, although we're starting to see a little bit of that already in 2012, but we think it'll increase in 13 and 14. And what not listed up there is another activity that we're participating in, and that is where insurers are acquiring providers, both hospitals and physicians. Many of you may have followed and read about Highmark, the Blue Cross entity in Pennsylvania, offering to purchase West Penn Allegheny Health System, the Jefferson Health System, both in Pittsburgh, and St. Vincent's Health System in the area. In terms of valuation, there are really three standard industry methods to value hospitals. We won't go into those in great detail, but they're listed there for you. Public company multiples are analyzed to look at multiples of revenues and EBITDA as indicated by the trading value of those public companies. We apply those multiples to the target hospital that is being valued. Similarly, we look at comparable transactions, those similar facilities that have traded and announced their sales price in order to look at the multiples for that. And the third method is a discounted cash flow approach, where projections are generated into the future with regard to the performance of the hospital, and then those future cash flows are discounted back to today's value. We use all three of those typically in our valuations and more or less triangulate that outcome to come to a narrower range of valuation. So what are some of the indicators in terms of need to affiliate? Obviously, when organizations can't meet their current or long-term capital needs is a major driver. As I mentioned before, physician alignment landscape. Many hospitals really feel the need to aggressively go after physician alignment opportunities. Ongoing financial problems, irregular financial performance, where there's aggressive competitor action, and the organization needs to respond in a significant way. Where there's major changes or challenges in the payer landscape, where the level of preparedness for rise in new healthcare delivery models increases, and specific major challenges that can't be changed. The strategic options assessment is a product that we use. Others in the consulting world also use similar sort of analyses, but it's an attempt to get in and to advise boards and executive managers in terms of the performance of the individual hospital that they oversee. In our case, we have an in-depth review of the business analysis in terms of its overall performance, all of its components with regard to its competitive position, its trends, medical staff, market area, market share, and that sort of thing. We also interview constituents, including directors and physicians and community leaders, and then do an in-depth financial analysis in terms of the ability to generate capital through traditional credit sources. Business risk assessment is reviewed, a business valuation is performed, and then a thorough assessment of strategic alternatives. What kind of structure might address the needs of the organization? And it very well may be consultative services that are required to improve overall financial performance, or it could lead to an outright sale, and many things in between. I'll close out my part of the presentation by talking about a couple of examples that we've been involved in to illustrate how many of our clients have found access to capital in this non-traditional method. The first relates to Montgomery General Hospital in Olney, Maryland. It's in Montgomery County, right outside of Washington, D.C., a very attractive, good demographic environment, a relatively small hospital at $115 million. Their situation was that they had debt capacity constraints that prevented them from executing on their strategic plan. Again, they had very favorable market demographics, but they were really just overshadowed by some of their competitors. And so physician recruitment was also a problem. We performed the strategic options assessment. The board determined that they needed to be aligned with a larger healthcare system in order to access capital and to get assistance on the physician recruitment approach. Ultimately, through a competitive process, MGH selected MedStar Health, which has hospitals in Baltimore and down into Washington, D.C., including Georgetown University Medical Center. And Montgomery General Hospital became an affiliate of that multi-hospital system. The next example is Morristown Hamblin Healthcare System. It's in Morristown, Tennessee, east of Knoxville. Knoxville would be the next major service area, if you will. Morristown had one competitor. That was a for-profit entity operated by CHS. By the time they had engaged us, they had come to the conclusion that they really wanted to negotiate a merger with Covenant Health, a well-known and successful nonprofit based in Knoxville. It was our directive to attempt to get the best terms possible with the merger with Covenant Health, both in terms of accessing capital going forward and active participation at the board level, both locally and at the parent corporation. And we were successful in getting that accomplished. The last example is a situation in which a fairly large nonprofit multi-regional health system, CHP, had a subsidiary called Mercy Health Partners in Knoxville. They determined that they needed to realign their portfolio. They identified two different regions in which they saw that tremendous additional capital would be required in order to make them successful. They decided to sell those regions off, one in Scranton and this one in Knoxville, to other parties, and to take the proceeds from that sale and to redeploy them in a more strategic manner within the state of Ohio. And so in this transaction, it's a 7 acute care hospital system, again based in Knoxville in the outlying metropolitan areas. We ran a competitive process, a lot of interest in the business. It's about a $600 million revenue business. And ultimately, the decision was made to sell to Health Management Associates for a purchase price reported out at $525 million. In terms of the additional benefits to the region, there was significant capital commitment going forward from HMA, continuation of charity care at levels similar to what had been provided historically, commitment to continue employment of existing staff near term, and a commitment to support various Catholic programs as well as donations to different foundations by HMA. That concludes my remarks, and I look forward to any questions that might arise during the course of the presentation. Thank you.
Thanks, Dave, for that discussion on the affiliation environment. Let's now turn to David Anderson for a discussion of transaction structuring options. David?
Thank you so much. We are delighted to be a part of this important webinar as well, and would like to share with you a little bit of information regarding how one thinks about the structure of these transactions. I would suggest to you that the first time we were involved in a transaction like this, I believe it was just after the Great Flood. It was 2 Hittite hospitals, and they proceeded to start drawing organization charts in the sand and lost the context. And since then, we have learned a number of really important lessons, and that is that if you're going to figure out the right structure, you have to start with a business case that makes sense to both parties and is compelling to both parties. And on the basis of that business case, the parties that are in the discussion can then decide whether the objectives they hope to achieve are compatible with one another, and they also can identify whether or not there are any constraints to the organizational form that need to be considered. And it's assuming those objectives and constraints are compatible between the parties, it impacts whether or not you have alignment around the best organizational form to achieve your objectives. Clearly, when you think about constraints to organizational form, beyond the usual issues of board size, board composition, et cetera, we also wrestle with questions of are these transactions between public or religious hospitals versus private hospitals? Do the debt documents impact the form that will be required? Are there regulatory considerations, third-party rights considerations, or accounting considerations, some of which we will get into in a few minutes, that need to be considered? And those lead you to think about best organizational form, and essentially the organizational form really addresses four main themes. What's the corporate form of the transaction? What's the governance structure of the transaction? What's the management organization of the transaction post-implementation? And what's the economic alignment that's being achieved? So we sort of use this template when we think about best organizational form and the options that make most sense in a specific situation. What are the lessons that we've learned from this? If I could advance the, yes, thank you. Essentially, if you start on the left side and work to the right side in that chart, you actually make more progress faster and you get clearer ideas than if you start at the right-hand side and try to backfill. It obviously impacts your ability to, in essence, be really clear about what you want and make clear about what you want from the relationship and get the right design. You also understand early on what are the debt documents, regulator, third-party considerations, accounting treatment considerations that need to be factored in. So let's look at each of these elements a little bit here and talk about what a compelling business case considers, and that is puts it on the right track, and what are the aspects of a compelling business case that tend to be on the wrong track. And I will tell you, by the way, that lawyers sometimes disagree with us on this because of antitrust and other concerns, and I'm sure we'll hear more about that in a few minutes. But you're on the right track if the business case, in essence, says we can actually bring down administrative costs. We are not going to have to increase unit prices as a result of doing this transaction. We can avoid future capital. We can actually combine some clinical services that will result in better quality, better safety, as well as lower cost. We can demonstrate that our physicians will have better and quality and safer alternatives to locate their patients to be served more conveniently. And if we can demonstrate that employers and insurers will have better care systems for their enrollees. So if the business case centers around those themes and makes a compelling case for that, we generally find that you're more likely to be on the right track. What are the things that, in terms of a business case, that sort of look like they're pretty weak? If people don't really talk about administrative cost reduction, they don't talk about what the cost effect is going to be, that's usually problematic. If they talk about pricing as sort of the advantage, or use those nasty antitrust words like leverage, smother, you know, the various words that we sometimes find creeping into documents inadvertently, problematic in a business case. If you don't think about future capital, that's a problem. If you don't think about clinical service organization, or alternatively, if what you're really doing is eliminating choice in a community for care by combining clinical services, that can be detrimental to your business case. If you're basically creating a scenario where physicians are likely to abandon a competitor hospital and limit causing a closure of a hospital, that's a little bit problematic. Or if you're in effect limiting choice of employers and insurers for their enrollees, that's a business case that's on the wrong track. But it's important to document these things and document them in plain language that's clear and compelling so that the parties understand what it is they're going to try to accomplish post-transaction. All right, let's talk a little bit about these third-party rights and accounting treatment considerations that have to be factored in. What we're finding in a number of transactions is many of our clients have had a creep of deals that were smaller in nature, but by and large have implications on a bigger transaction or limit options going forward. So, for example, clients that maybe have been in the business of employing physicians, but those physician contracts have change of control provisions that allow the physicians to avoid their non-compete, or possibly even with independent groups that are in joint venture agreements where they have approval rights that need to be considered. Or examples of where we've developed property on a campus and we have sale leaseback considerations with change of control provisions that impact the acceleration of some sort of cash payment or whatever. Important to understand those early. Or change of control provisions in managed care contracts need to be understood. So, if you think about third-party rights, the reality is that we are dependent on those contractual relationships that we have established that may not have considered the fact that we might want to consider a different kind of transaction or a broader transaction down the road. And it's important to identify what those things are early because they actually can impact organizational form. The last subject on this has to do with the recent accounting requirements that now between not-for-profit systems require, if essentially one party is technically the acquirer, whether we call it that or not, whether there's cash paid or not, that the acquiree needs to have a revaluation done of their future cash flow and the value of their balance sheet, and actually reset the balance sheet to what it would be worth based on the valuation principles as outlined by Dave earlier. And that means, for example, quite often you might be in a situation where the future cash flow of the business will not support the historical cost of the property, plant, and equipment, and there would actually be an adjustment on the acquiree's books to reduce the value of the property, plant, and equipment. It can be significant, and so it's important to understand that accounting treatment consideration early in the discussion versus later. So if the business case is in essence requiring the parties to or promotes the parties setting fee-for-service prices together, to allocate clinical services across geography or access capital together, then basically corporate alignment needs to be high, governance alignment needs to be high, management alignment, at least from a business perspective, needs to be high because after all you have to execute, and the level of economic alignment between the parties needs to be high. So you need to, in effect, think about the fact that you are really locked together if you're really seeking to set prices together, allocate clinical services, or access capital together. And when you think about the alternatives that you have to achieve this, basically, in our mind, there are, and I'm sure people can come up with variation 4A, 4B, 4C, 4C, 4D, but we think there's about 4 broad ways these things happen. One option, and the first option that's laid out here, is essentially a situation where System A wants to exit a market and they're going to transfer control, and it will not have any significant continuing involvement going forward. And David illustrated some of those transactions in his remarks. And those are really appropriate when System A or Hospital A is designed to exit the market and not continue to be involved. So that's sort of the traditional acquisition sale model. Second option is where you have System A decides it's going to merge into System B, and System A is not going to receive any economic consideration for that transaction. Those are very common transaction structures between religious systems, private not-for-profit systems, but less common in where you have differences in ownership. Usually what happens is Health System A continues to have an ongoing role in Health Systems B governance. It may be a minority role in the governing board or some other structure or some other level of representation. And quite often, Health System B, the parent company, will rebrand its name to basically reduce the market perception of it being a takeover. And, the traditional wisdom here now is that the name of the company should generally be 3 syllables, starting with a vowel and ending with a vowel. Alina, Omega, Amoeba, pick your name of choice, but essentially you'll see an awful lot of them pattern after some word like that. Third form is where Health System A and Health System B actually form a new parent, Health System C. And these are common also in situations where you've got similar ownership structures. Obviously, the governance and management is negotiated in these transactions. And sometimes Health System A and Health System B continue to be the members of Health System C, and they retain some limited amount of responsibility or reserve powers over that system. The final option that we are seeing increasingly discussed is this whole idea of joint operating companies or joint operating agreements. And in this case, what you have is a Health System A and a Health System B. They form a new company, and that new company has substantial governance and management responsibility over both Hospital A and Hospital B in this situation. These are we will more typically see these where the ownership structure of the two systems are different. So, for example, a religious health system and a private not-for-profit, a public system and a private system. So you'll tend to see those in that form. What's important to understand is JOCs are not a try it and see if you like it model. They are the functional equivalent of a merger, and if not for other considerations, you probably would have merged to begin with. So think of those as a merger, but it's just a different form of a merger. Don't think of it as a try it and see if you like it model. We will also tell you that these are legally complicated to develop. There's a fair amount more negotiations that need to take place, but they actually can be functionally effective, and there are those in place today that actually can demonstrate that, and we'll show you a couple of examples in a minute. So what are some of the primary characteristics of these joint operating company models? The main ones that we would highlight here is that the balance sheets and income statements of System A and Hospital A and then System B and Hospital B, they actually remain separate. They continue to own the assets, control those assets, consolidate those assets with their enterprise. The financing documents and the debt documents generally remain separate unless the two systems agree to do something differently. And we've seen situations where they started with separate financing, and then System A discovered that the credit rating of System B was higher and that interest costs would be reduced for the joint venture by using System B's credit rating to finance System A assets. And so they chose to do that. But generally, they remain separate. Key is around economic sharing, and essentially what happens in these JOCs is that the profits and losses, it could be an operating income or excess margin with some adjustments for perhaps unrestricted contributions. But the operating margins of Hospital A and Hospital B are added together each year and then redistributed on a pre-agreed to a formula that was negotiated at the beginning of the transaction. We could be splitting profits on a 50-50 basis. We could be splitting profits on a 75-25 basis. Whatever we agreed to up front, that value is set up front, and that becomes the percentage that's used going forward. Fourth, the two systems actually have to delegate substantially all operating decisions to the joint operating company board over those hospitals. So they have minimal reserve powers other than to appoint their own directors to their board and some limited powers around capital approval, et cetera. Obviously, ethical and religious directives will apply to a religious hospital, a Catholic religious hospital, if that were the case. Sunshine laws need to be understood if it's a public-private transaction and the impact it might have on the JOC. But what we've learned is that it's really helpful if the JOC board and all of the hospital boards are the same people, and that you have a single management team over the JOC and the hospitals around which it manages. It reduces confusion, improves efficiency and effectiveness of decision making. The Achilles heel in these transactions quite often have to do with thinking through in advance how future capital expenditures are made and who writes the check or who incurs the debt. So it's really important to document and describe that up front. And typically what happens if a capital expenditure has been approved by the joint company, but System B, for example, doesn't want to pursue that, it doesn't want to commit the capital to it, if System A does that instead, then there's oftentimes an adjustment in the income sharing or some return generated to the System A side for making that investment. So those are solvable issues, but they need to be thought through up front. The last thing I'd like to just share with you is what we characterize as the best examples of joint operating companies in terms of their performance. One example would be the Tri-Health system in Cincinnati, which was formed in 1994 between Good Samaritan Hospital of Cincinnati, which is now was previously with another Catholic sponsor that merged into Catholic Health Initiatives, and Bethesda Hospital, Inc. We had access through public sources to the audit reports for both of these participants in Cincinnati, and would suggest to you that they have been very successful from an economic perspective. So in 2011, the total assets were about $1.5 billion, of which $885 million of it was equity. They had $1 billion worth of operating revenues, and their operating income was $48 million, or about 4.8% operating income. The cash flow from operations, that is operating income plus interest and depreciation, was $106 million on $1 billion in revenues, or something north of 10%. In looking back over a number of years, 2011 is not an anomaly for that organization. It has consistently performed very, very well in that community. Baycare Health System in Tampa is another example. Again, you'll see it's a Catholic, non-Catholic Baptist organization in terms of its original sponsors. Formed in 1997, the company, as of 2011, was $4 billion in total assets, of which $2.4 million of it was equity. It had $2.4 billion in operating revenues from its business operations, had earnings of $165 million on $2.4 billion in revenue, and $352 million in operating cash flow, or something, in north of about 13%. So very successful from an economic perspective. But having said that, the principles that they apply in the context of full governance alignment, full economic alignment, full management alignment are really critical to the success of the operations. So with that, I'm going to pass the discussion over to Heidi.
That's great. And Cheryl, did you want to make a CLE announcement at this point?
Yes. Thank you, Heidi. For those of you who are joining us from the state of New York, we have a CLE code available. That code is 0, the letter O, Q, 6, B as in boy. Once again, it's 0, the letter O, Q, 6, B as in boy. Thank you.
Great. So I'd now like to pick up on some of Dave's comments, and his focus primarily on financing and debt and some of the decisions around whether to keep that debt separate or to work to bring that debt together. My section is going to concentrate on 5 particular areas in a lot of the deals that we've been working on in the affiliation area between nonprofits. We've been spending a lot of time focused on the treatment of the transaction under master trust indenture documents, various bank and swap document covenant matters. We've also been focusing on bond indenture provisions relating to substitution of security. We'll also cover tax issues, although it won't be in great detail. But of course, there are many tax issues to consider when looking at debt management issues. And then last but not least, disclosure matters. Turning to some practical considerations, I'd invite all of you who are focused on affiliations, either at the beginning of the process or in the middle of the process, to keep a few items in mind as you kick off the process. The first being, what is this? When I get a call from a client that might be focused on acquisitions or an affiliation, one of the first things I ask myself is, are we talking about an acquisition? Are we talking about a consolidation or one of the other variations that Dave just discussed? So understanding the business deal, understanding the end game here is fundamental as you then start thinking through document issues. One of the primary document issues to get on top of sooner rather than later is whether the documents require a redemption or defeasance. We've certainly seen situations where the document, by virtue of the transaction that you're structuring, would actually require a redemption or defeasance of debt. Also key to the start of the transaction is how is the transaction going to be affected? Are you looking to do a membership substitution, or are you looking at a transfer of assets? Most master trust indentures and bank and swap documents have specific provisions dealing with those items. Likewise, what do your documents say about change in control? One of the structures that Dave mentioned involved creating a new parent. If that's the situation, one of the key things, practical considerations to keep in mind is what do your documents say about transferring assets out of the obligated group? That is, how would that new parent be supported financially? And then last but not least, one of the other practical considerations to keep in mind as you're kicking off is what sort of diligence you and your team will need to undertake to fully understand the transaction. So, getting to the first topic, how is your deal treated under the master indenture? This becomes fundamental to understanding certain of the document provisions related to sale of assets, change in control, and merger. Those provisions are typically all located within a master indenture or supplemental indenture, and those provisions obviously become very relevant as you're organizing your deal. One of the other key considerations is, again, relating to the end game, what do you want to do with your master indenture? Is it likely that your master indenture will be defeased as part of the process or continued? And if the master indenture is continued, what is the practical effect of having two outstanding master indentures? One of the considerations that we've been seeing a lot of and wrestling with is one of the outcomes of having separate master indenture is the need actually for separate financial statements. And I know Dave earlier talked about accounting issues. So we flag that because, again, one of the issues that we're seeing in terms of master indenture continuation is the wrinkle of having separate financial statements. And that leads me to one of the additional practical considerations. We found in many of the recent deals that we've been involved in that it's absolutely key to ensuring a smooth transaction to make sure that your financial reporting team is a member of your deal team. Getting the financial reporting group involved, early and often seems to have facilitated a lot of the deals that we've been working on because you're continually bumping up against auditing and financial reporting issues. The structure that you decide on or the structures, the options that you're looking to develop will largely be driven by existing bank and swap document covenants. There are several key provisions to be on the lookout for, and you'll probably hear me talk about this again during the presentation. Just a word on organizing the deal. It's very important during the diligence process to gather not only each bank and swap document that you might have, but also every master indenture and supplemental indenture. Not only are we seeing important covenants developed in the credit and reimbursement and liquidity agreements, but we're also, of course, seeing a lot of covenants running for the benefit of insurers and banks in supplemental indentures. And one of the provisions that we're also seeing that seems to be proving to be a sticking point or a discussion point are seemingly innocuous provisions related to changes in articles of incorporation or bylaws. Our recent experience suggests that those provisions actually might be difficult to manage, and as you're working through and structuring your transaction, keeping an eye out for those types of seemingly innocuous provisions are key. Again, returning to kind of the provisions to be on the lookout for, again, provisions relating to mergers, transfer of assets, change in controls. Also, fundamental to the start of a deal is understanding what sort of approvals and consents might be needed, either from your bondholder, from an issuer, from a bank, from a swap provider. You get the idea. When you're talking about pulling together hospitals in the form of an affiliation, a merger, or consolidation, no doubt there will be various approvals and consents that are required. So understanding where those are and what consents are required are key. And again, as I touched on earlier, what are the required redemption or defeasance provisions that might be in your document? Continuing on, and we'll cover obligation substitution in greater detail, we've seen recently in some of our in some of our credit agreements, various restrictions on admission to and exit from the obligated group. And for those with obligated group that also might include affiliates or designated affiliates, we've seen some bank documents that really focus on tests for adding a designated affiliate, adding an obligated group member, as well as the exit. So just be mindful that a lot of times the documents focus not only on the entry into, but also the exit from. Upstreaming restrictions in your document, and again, this falls into the transfer of asset provisions, but these upstreaming restrictions become very key, especially in the context when you're creating a new parent. And getting back to the point I raised earlier about how is that new parent going to be structured and supported financially, especially to the extent that that new parent isn't automatically folded into a particular obligated group. It raises very interesting questions in terms of putting money or basically pushing money outside of the obligated group. And of course, the existing lien and lien basket provisions in your documents are key. In terms of substitution of security, as Dave mentioned, there are a couple ways to think about debt. You can either leave debt outstanding, or you can consider consolidating the debt and potentially restructuring it. One of the things that we've been dealing with lately with entities that don't necessarily want to restructure or refinance debt, but yet want to bring a new hospital affiliate into a particular obligated group, we've been wrestling with this concept of substitution of security. Many bond indentures as well as master indentures have obligation substitution provisions. With that said, not all bond indentures have these provisions. And even if a particular hospital does have a substitution, a security provision in a bond indenture, it may not be uniform. So practical point is you might think that you have the ability to substitute, but check each bond indenture just to make sure that, in fact, those provisions and requirements are uniform. And the other point to note, we've seen recently and heard recently in some of the deals that we're involved in that these substitution of security provisions are becoming more scrutinized by investors because obviously in the last couple of years a lot of these substitution of security provisions have actually been utilized to bring in new members into a credit group and to otherwise substitute security for an entity that may have been acquired. So we're seeing a lot more questioning of these provisions, and in some cases, pretty significant pushback. For those of you on the phone that may not be familiar with this provision or are wanting to return to your offices and start reviewing bond transcripts, I've outlined on the next slide the substitution of security provision, and again, they're not all written this way. It might sound easy to simply substitute security, but it's, in actuality not as easy as it sounds. There is a process that one must go through, and particularly the bond trustee must go to, in order to surrender an obligation. And that process usually involves opinions of both corporate counsel as well as bond counsel, evidence of compliance with tests. That is, when you're bringing somebody in under your existing master and providing a replacement note or a substitute note, what are the various tests that need to be satisfied, both under your documents, but as well as under the documents of the entity that's coming in. And then also noting at the bottom of the screen, noting that written confirmation from each rating agency, that is making sure that the rating agency is reviewing the process, that also needs to be built into any sort of transactional transaction involving substitution of securities. I'd now like to turn to tax issues and some practical considerations. I don't want to spend too much time on the tax issues because they do tend to be, the issues tend to be analyzed obviously in the context of the particular fact pattern and the particular debt. And the tax issues are very complex, of course, and varied. One of the practical considerations is to involve your corporate counsel or bond counsel early in the process. And we found in transactions where counsel has been brought in, prior to or at that letter of intent phase, that those deals have gone very smoothly, especially to the extent that your letter of intent will outline board membership, which becomes a key in acquisition finance, as we'll get to a bit later. We do get asked quite a few questions about acquisition finance, given its benefits. As I've noted out on the next slide, and I invite you to take a look at the regulation that I've noted there, but the tax treatment of any financing of the acquisition payments will depend largely upon whether the financing is treated as an acquisition, new money financing, or as a refunding of the existing debt. There are really three different treatments of refinancings for tax purposes. As outlined below, a transaction can be structured as a refunding. It can be structured as a hybrid new money financing, which generally involves transactions between affiliated persons, and refinancings that are treated as new money bond issues that are not otherwise subject to those special rules referred to above. And those are referred to as pure new money financings, and often are entitled to, the most benefits of acquisition finance. Our current experience has been that it's common for the acquisition of a membership interest of a standalone or a smaller system by a large system to be treated as a pure acquisition financing, again, entitled to more benefits of acquisition finance. But that affiliations between larger systems have been more commonly treated as hybrid acquisition financing, again, because of that affiliated persons concept and largely given the board composition. So again, where we've seen larger systems tending to acquire smaller systems or standalone hospitals where perhaps a board membership on the acquiring entity isn't going to be as prevalent. Those seem to be treated as pure acquisition financing. And again, affiliations between larger systems, those that do take advantage of acquisition financing, those have generally been treated as hybrid acquisition financing. And again, as noted on the next slide, transaction between affiliated persons, the benefits are generally lessened in the case of such transactions. The next two slides provide an analysis of various categories or objectives in structuring your refinancing, and it compares the notion of refunding, hybrid, and pure new money transactions. I'm not going to walk through all of them, but rather will forward to the practical considerations or some of the benefits of acquisition finance. And one point that has proven to be very important in recent years is the benefit of acquisition finance in that would not seem to require a private use look back or extensive retrospective due diligence, at least to effect a new financing. And to some extent, we're avoiding some of that tax diligence as it relates to private use. Acquisition financing would seem to permit a fresh start for private use purposes. We've also seen that acquisition finance can be particularly useful when prior tax compliance generally would not carry forward. So again, in the advanced refunding context, we've also seen it to be very, very useful. Continuing on, in terms of managing the debt process and the structuring process, one of the considerations, again, practical consideration, is the need for an appraisal. Most of the transactions that we've seen recently, obtaining an appraisal seems to be part of the process. But as a practical matter, acquisition financing treatment depends upon appraisals of the acquired property. The appraisal should be as close to the acquisition date as reasonably possible, and the appraisal should separately state the values of assets eligible for tax-exempt financing. And ideally, the appraisal should also state the remaining reasonably expected economic life of the acquired assets. So there may be a variety of reasons why one would want an appraisal in the context of one of these affiliations. But again, keeping in mind that an appraisal will have value to you and to your bond counsel in the context of an acquisition financing. I'd like to conclude with a few words about disclosure because, again, one of the first questions that we get when we kick off a deal is, what do I need to be telling my investors about this deal? Or we're thinking about doing a deal, at what point do I need to tell the market? And so the next slide refers you to Rule 15C212. I suspect many of you on the phone have continuing disclosure undertakings, and a relatively recent change requires event disclosure if you are involved in the consummation of a merger, consolidation, or acquisition, or if you are entering into or terminating a definitive agreement, qualified, of course, by materiality. We are certainly working with clients to develop meaningful disclosure related to mergers and consolidations. And again, I invite you to refresh your memory about the rules of 15C212 because we certainly are seeing disclosure being discussed both before, during, and after one of these affiliations. As it relates to disclosure matters, one of the things that we're working with clients on, both during and to some more extent after a deal, especially in preparation of doing some sort of refinancing, is it's important to consider the use of what audited financials would be used in future offering documents, and in particular, to the extent that you are going to need ongoing cooperation from management or an existing auditor, getting some understanding of what that participation will be on a going forward basis seems to be important. Understanding what representations might be required, say, in a bond purchase contract or in closing certifications, what representations can be made by current management about the acquired system or hospital? That seems to be key. And likely, what current management of the acquired system or hospital will need to be involved in any sort of debt financing. Again, just getting an understanding of what either the investment banker or underwriters council will be requiring in terms of the use of the audited financials, the preparation of those financials, as well as obtaining representation. Those all seem to be points that we've been working through subsequent to the transaction and prior to doing some sort of refinancing or acquisition finance. And likewise, developing an understanding of what Appendix A information will be needed, that has also been very key. Understanding utilization statistics, I guess the point would be it goes beyond the financials and gets into utilization statistics, management information, but understanding how the disclosure will fit together from a consolidated standpoint. Again, we've spent considerable time working through that. I realize I raised many issues or points as it relates to document matters and debt management. Certainly happy to answer any particular questions you might have at the end of the presentation. With that, I will hand it over to you, Rick, to discuss Catholic, non-Catholic considerations, State Attorney General, and antitrust issues.
Thank you, Heidi.
And just before we go to Rick, for those of you participating from New York State, the second CLE code is as follows. It's C as in cat, J as in Jack, W, M as in Mary, 3. Once again, C as in cat, J as in Jack, W, M as in Mary, 3. Thank you.
Listening to the prior speakers, it's very obvious that there are a multitude of legal issues in connection with transactions involving two nonprofit hospitals or systems. Today we're going to focus on three particular areas: considerations when there's a transaction between a Catholic hospital and a non-Catholic hospital, the role of the State Attorney General, and then finally antitrust issues. The background for the discussion of the Catholic hospitals focuses on the ethical and religious directives for Catholic health facilities, which have been adopted by the U.S. Conference of Catholic Bishops. In essence, these prohibit the provision of abortions, euthanasia, or direct surgical non-medically indicated sterilization, contraception, infertility services in a Catholic hospital. The local bishop is responsible for the interpretation of the directives as it relates to any particular procedure in a hospital. When a Catholic hospital acquires a non-Catholic hospital, or vice versa, there are issues raised with respect to community access on a continuing basis to reproductive services. So the challenge is how to implement the transaction without violating canonical laws. This is obviously a major point of negotiation in the early stages of the transaction. It's important to remember that all hospitals are accountable to state and federal regulators for their operations, but Catholic hospitals in particular are also accountable to their sponsoring orders for the local bishops and ultimately to the Vatican, as we'll discuss. So it's a very good idea to have discussions early on with a canonical lawyer and even a medical ethicist if necessary to understand the ground rules under which these transactions should be conducted. I thought the best way to describe this would be to use a few examples that I'm familiar with. Historically, one way to deal with a situation in which a Catholic hospital acquires a non-Catholic hospital is for the non-Catholic hospital to fund a family planning service agency prior to the closing. In this instance, the non-Catholic hospital sets aside funds which are transferred to either an existing or a new agency such as Planned Parenthood to assure that there are continuing reproductive services in the community, since they will no longer be available at the hospital once it becomes a Catholic hospital. This can be structured as an allowable exception to the typical ordinary course covenant in transactional documents, either through timing of the transaction or an adjustment of numbers to reflect the reduction of assets of the nonprofit non-Catholic hospital prior to the transaction closing. Technically, from a canonical standpoint, the Catholic hospital will not have materially participated in the transaction if it occurs before the closing takes place. Also, this is very likely to be acceptable to the Attorney General of the state, who will be scrutinizing the transaction regarding community access issues, which we will discuss further in the next section of my speech. In the second example, we have a non-Catholic acquiring or combining with a Catholic hospital. If, in fact, there is church property in connection with a transaction of this nature, the church property is subject to the authority of the local bishop and the Vatican. The transaction itself will be conducted only with the permission of the local Catholic official at a first stage. The process is that the local bishop will initiate a request to the Vatican in which he will describe the nature of the transaction, the ongoing services to be provided, the conduct of the practice of the hospital after the closing. After a period of time, hopefully the Vatican will respond with a 1 or 2 sentence document in Italian which will grant the request. It does not typically have any specifics as to the transaction. It basically accepts the request and grants it from the bishop. And that document is called an indult, I-N-D-U-L-T, which in my experience has been signed by a secretary to the Vatican. Generally speaking, the health system, whether it's in a combined system or 2 hospitals coming together, system agrees to maintain the Catholicity of the hospital, observe the ethical and religious directives, maintain a Catholic chaplaincy to provide for spiritual needs of patients, so-called pastoral care. Sometimes this is referred to as a lowercase c Catholic hospital. In the third example, and this is a more recent development that we have seen, in preparation for a combination of a Catholic and non-Catholic hospital, the non-Catholic hospital permanently delegates to a standing committee of its board the oversight of women's health services within the hospital. The standing committee will have no members who are also members of the board of a parent organization or of the Catholic hospital board. The delegated subcommittee will oversee the service line for women's health services and will assure the segregation of revenue by billing codes. All prohibited procedures under the directives will be segregated, and all net income and expenses from the prohibited services will be segregated. And oftentimes the net income will be donated to a community-based 501c3 to support continuing services for reproductive health in the community. Another alternative along a similar line is an ambulatory surgery center created by the nonprofit hospital prior to the transaction and funded and operated in a similar manner with a separate board that is enabling reproductive health services to continue to be performed in the community, particularly if there's not a planning agency within the community already established. Finally, one example that I was involved with that was somewhat different, having had the experience of seeking an indult from the Vatican in connection with an earlier transaction in my own experience, I went to an early meeting with the sponsoring nuns of the other party to the transaction and asked them whether there were any reasons why this transaction would not require an indult, and they assured me that it did not. And I asked them if they had any issues with serving on the board of a parent of the two hospitals that were coming together, one Catholic, one non-Catholic, and they assured me they did not have any problem with that, even though they recognized that the non-Catholic hospital would be performing prohibited procedures. Obviously, the Catholic hospital would continue to observe Catholicity. What I discovered in the early discussions was that the hospital funds had come from an order of nuns who had, during the course of the Vietnam War, taken some positions that were not politically acceptable to the local bishop, and as a result, they were no longer answerable to the Vatican. This transaction, as I mentioned, was structured as a consolidation, and it went forward with the Catholic hospital continuing to be operated as it had in the past. One other item I may mention is that if a Catholic hospital has an ownership interest in a medical office building in connection with one of these transactions or otherwise, and the obstetricians or gynecologists in the community have an interest in performing reproductive services that would otherwise be prohibited by the ethical and religious directives, one way of structuring this would be to change the ownership of the medical office building to an independent owner, either through ground lease or sale, and allow the independent owner to lease space without the restrictions of the ethical and religious directives, and to enable the medical office building to, in fact, have tenants who will perform prohibited services. As I alluded to earlier, the structures that we have discussed would also be reviewed by the State Attorney General in those states in which the Attorney General exercises authority over charitable assets. In most states, the Attorney General is deemed to be the supervisor and monitor of assets that are held by a nonprofit which are technically impressed with a charitable trust. Charitable trust are restrictions imposed by the mission of the organization or expressly by donor gifts. State laws authorize the Attorney General to approve the maintenance of assets held in charitable trust, the transfer of those assets, and changes of membership in nonprofit organizations. It is very important to check state law of the hospitals engaged in the transaction in order to assure that you are complying with the Attorney General's rules with respect to your transaction. It's very possible that there may be a court involvement or hearings necessary for these transactions to go forward. I'm going to focus specifically on the Attorney General of California, where my personal experience is. It, I think, has been at the forefront of Attorney General actions relative to these types of transactions. Initially, the statutes in California authorized the Attorney General specifically to monitor transactions between nonprofit hospitals and for-profit hospitals because of fear of the use of assets and the tax benefits that had previously accrued to the nonprofit being somehow obtained by the for-profit successor. However, shortly after the rules were adopted to govern nonprofit to for-profit transactions, the legislature extended the role of the Attorney General to also monitor transactions between two nonprofit organizations. So there is an express approval requirement by the Attorney General in California. I think it's interesting to look at the considerations that the Attorney General undergoes in evaluating any of these transactions. They're listed here. Fair terms means that there have been arm's length negotiations. Oftentimes there may be a much smaller organization than a larger one in one of these combinations, and it's important that the terms be fair to both parties and consistent with their mission as articulated in their articles of incorporation. There should be no private inurement, which would be any personal benefit to the executives of board members or officers of either of the entities as a result of the transaction. The transaction, to the extent it involves any exchange of money, should be at fair market value with an outside appraisal. There should be no manipulation of the fair market value by the parties. There should be no breach of trust with respect to the purposes for which each of the nonprofit organizations has been formed. There needs to be sufficient information exchanged with the Attorney General to enable it to evaluate the transaction. The Attorney General will pay particular attention to the effect on the availability of services in the community, the whole notion of access to care, in part what we've discussed in the first section relative to the Catholic and non-Catholic hospitals coming together. And then generally, the subject of public interest relates to the survival of the hospitals in the community, providing the needs for that community. And then the use of proceeds comment relates to whether the proceeds of any transaction have been continued to be used to support the mission of the organizations as articulated in their articles. Under regulations that have been adopted in the state of California, there's a request for submission that's made to the Attorney General, and this involves the review by the Attorney General of prior reports and then ongoing monitoring of each of the following. The community needs assessments, which are regularly reported to the Attorney General. Description of charity care provided, that's both in the amount of dollars and the consistent standards applied across prior reports and the expected charity care to be provided going forward. And interestingly, even though this doesn't relate to charitable purpose and or access to care, the Attorney General of California, which may be unique in this regard, also looks at patterns of employee staffing and input to the transaction, guarantees with job security and continuation of jobs, and employee wages, benefits, working conditions, and protections going forward. Typically, the Attorney General will review materials that have been submitted and can ask for additional materials if they're inadequate for its purposes, and then will issue an order to the acquiring party of the nonprofit hospital, which will require that they maintain for a period of not less than 5 years a number of different items as listed here. The number of licensed inpatient beds, so that there should be no diminution of service without prior notice and approval by the Attorney General. Charity care delivery levels, as I mentioned earlier. A contract with the Medicaid program to assure that low-income and indigent patients will continue to be served by the hospitals. Emergency care service levels should be no less than what they were prior to the transaction. And then critical community services should be maintained. And this obviously has led to focus on reproductive services when the Catholic hospital is involved in the transaction, continuing service to the Medicaid population, and continuing access to emergency or trauma services that pre-existed the transaction. That section was dealing with state Attorney General related issues, and now we're going to move on to federal issues, specifically antitrust issues and Hart-Scott-Rodino pre-merger notification. Notwithstanding healthcare reform, which has a tendency to cause people to think about consolidating, fighting anti-competitive effects in healthcare markets remains a top priority of both the Federal Trade Commission and the Antitrust Division of the Justice Department, and they have announced as early as a week or two ago that they will continue to pursue healthcare mergers that they believe threaten competition. Both Daves have already talked about the drivers for consolidation that have taken place in the marketplace, and that helps to explain why there's more merger activity, but it doesn't help to explain at all the focus of the FTC and the DOJ. Their view is the higher the concentration in any market, the greater potential there is for increased prices and control of prices by providers. Their primary focus is the market impact on the primary service area of the hospitals, where 75% of the patients come from by zip code of residence. Interestingly, in an amicus brief filed by the American Hospital Association within the last 2 weeks, the hospital has asked, in connection with an antitrust case, that the court suggest that the agencies adopt a new approach or an enhanced approach to the review of these hospital transactions, which better reflect the changed environment that's taking place as a result of healthcare reform, and the impact of trends that should be considered include the significant reimbursement pressures that are coming about as a result of changes to the Medicare and Medicaid programs, the overall shifting from a volume-based to a value-based payment system, the economies of scale that are strongly suggested by all of the activity that has been noted in the marketplace, and the increased need for access to capital to pay for ever-increasing technology and equipment costs. Two examples of recent activity, and then we'll go into a discussion of the mechanics of the Hart-Scott-Rodino. In April of 2012, the FTC obtained a preliminary injunction stopping a merger in Rockford, Illinois. This is a situation in which there would have been a reduction in the number of hospitals in the community from 3 to 2 in the service area. The proposed merger would have resulted in a 64.2% share of the general acute care admissions in the service area. There was a fear of future price increases from the FTC. Interestingly, in the agreement, there were a number of stipulations between the parties as to activities post-closing, but there were no covenants going forward as to preclusion of price increases, what the FTC looked for. So the transaction was abandoned by the parties. This is a transaction that had been tried before and had been opposed as well. The lesson of this one is it may be important for the parties to covenant with respect to what they intend to do relative to pricing going forward so that the FTC doesn't have this concern. The second example is a hospital transaction in Toledo, Ohio. In March of 2012, the FTC ordered ProMedica to divest a hospital acquired 2 years earlier, interestingly enough, since the transaction would lessen competition and raise prices through unilateral effects. In this case, the merged entity would control 58% of the general acute care market in the service area and 85.5% of the inpatient obstetrical services. Now, the interesting aspect of this case is that normally the focus is on the general acute care inpatient services, which was enough for the FTC to order the divestiture. However, they pointed out that the concentration on inpatient obstetrical services was well in excess of their concentration concerns. It's important to note that in this instance, the payors testified as to the impact of price increases, which could be demonstrated as a result of the combination. So the practical lesson for this one is, as a heads up for the future, you need to think about doing a specific service line analysis if this is the direction that the FTC is going, even though no one contracts separately for obstetrics gynecology services. Now, the mechanism that has been in place, notwithstanding that fact pattern in Toledo, the mechanism in place to allow the FTC and the Department of Justice to get an early warning of these transactions is the so-called Hart-Scott-Rodino pre-merger notification adopted in 1976. This prohibits the closing of a transaction that meet or exceed the Hart-Scott-Rodino thresholds. Now, of course, this is not limited to hospital transactions by any means. You will read about Hart-Scott-Rodino filings in connection with other transactions outside the healthcare industry. But basically requires the filing of pre-merger notification form with a 30-day waiting period for most deals. Failure to comply can result in penalties. And even though the FTC and Department of Justice technically can later challenge the deal, as a practical matter, they rarely do. One exception was the Evanston Northwestern deal and the ProMedica transaction we already talked about, because it's really difficult to unscramble an egg. The threshold questions for Hart-Scott-Rodino filing are whether it involves interstate commerce, and you can assume that it will for any domestic hospital transaction because of the nature of relationships with service vendors. The current size of transaction test, which adjusts every year, is $68.2 million, and the size of the parties test, either party, being larger than $13.6 million. The form generally takes about 2 to 3 weeks to prepare. It has to be filed by both the acquiring and the acquired party. Filing by the acquired party tends to be less complex, but a lot of information needs to be provided as described here. The SIC code is the standard industry classification code for the lines of business that are being done. The most important element of this from the hospital's perspective, I think, is the so-called Item 4C. Sometime after the adoption of Hart-Scott-Rodino, I asked one of my antitrust experts how it is that the FTC or the Department of Justice could so quickly review the documents, they have 30 days, to understand what the consequences of the transaction were. And they said it's very simple. They go to the marketing department. The materials that are called for in item 4C, which is quoted here, will show you exactly what types of information are called for. And I've given you a couple of examples on the next, 3 examples actually, on the next pages as to some materials that came from marketing departments. In the first case, an officer prepares an internal presentation recommending the acquisition. The list is an opportunity of the deal and elimination of the competitor, obviously leading to higher concentration in the marketplace, a concern for the FTC. In the second example, an officer of C prepares a financial model of projected sales after a deal is consummated, and then there's a quote: "We will have dominated market share of the industry and anticipate after 1 year taking a blank price increase." Obviously not to be included in materials. And finally, consultant prepares a market analysis stating that some of the customers may not like the transaction, but they have no real alternative, at least in the short run. The process after the filing is you can request an early termination, which can allow you to close your transaction early if granted by the FTC or Department of Justice. Otherwise, you have to wait for a 30-day period for no objection. If there are any objections, then the period can be extended. They may ask for a second request. And there can be telephone calls to customers, competitors, and payors in the marketplace by the FTC in order to determine what the impact of the transaction will be. Finally, if there is a second request, it can be onerous and burdensome. It can extend the waiting period another 30 days after substantial compliance. Having been through several second requests, this is a huge undertaking, probably requires some meetings in the Department of Justice and the Federal Trade Commission. And I guess the best advice I can give is to use experienced antitrust outside counsel to review the filing and the document submissions to lessen the pain from the Hart-Scott-Rodino filings. That concludes my comments.
Rick, thanks so much. This actually wraps up our presentation. I know we indicated that we would take questions and answers. Unfortunately, we have run through our 90 minutes, but we thank you so much for joining us today. We invite you to contact any of today's speakers if you have questions or if you would like more information on their particular topics. Contact information for the 4 of us is included. Just a reminder that today's program is being recorded and will be available on Foley's website early next week. Finally, please take a moment to complete a brief survey about this conference. Your feedback is so important to us, and we would like your help in selecting future topics for future programs. And a reminder that we do have 2 additional webinars scheduled for December and early in 2013. We will be sending out invites to those just as we did for this program. Again, thank you for joining us.
Ladies and gentlemen, thank you for participating in today's conference. This does conclude the program, and you may all disconnect. Everyone, have a great day.